May 26, 1930, Washington, D.C. In a significant interpretation of the nation's prohibition laws, the United States Supreme Court ruled today that purchasing liquor for personal use does not in itself violate the Constitution, even under the constraints of the 18th Amendment and the Volstead Act. The decision, delivered by the High Court in a majority opinion, clarified a legal gray area that had long puzzled citizens and confounded law enforcement. While the manufacture, sale, and transportation of intoxicating liquors had been strictly prohibited since the ratification of Prohibition in 1920, the ruling affirmed that the act of purchasing liquor, particularly when not part of an illegal commercial transaction, did not constitute a direct breach of constitutional or federal law. The case at the center of the ruling involved an individual who had acquired alcohol through a non-commercial arrangement and faced prosecution under Prohibition statutes. The court determined that the law did not extend to mere possession or personal acquisition, so long as the individual had not participated in unlawful manufacturing or distribution. Critics of the decision voiced concern that it might weaken enforcement of prohibition, already under growing strain due to widespread bootlegging, organized crime, and increasing public resentment. Supporters of the ruling, however, praised the court for reining in what they viewed as excessive overreach and restoring a degree of personal liberty. The judgment arrives at a time when the national conversation about prohibition is shifting, with mounting calls for reform or repeal. This decision may further complicate the work of federal and local officials charged with upholding prohibition laws. For now, Americans are left with a clearer, if still contentious, understanding. Buying a bottle of liquor may be morally questioned by some, but it is not by itself unconstitutional.